Welcome to Rebel Chaser. My name is Gail, and I have a clip for you from Judge Raquel West in Texas. She is sentencing a defendant who the prosecutor calls a professional thief. And it seems like she just can't help herself. She has a plea deal, and Mama's in the courtroom, and I don't think Mama is too happy with the way things ended up. She's not angry, but she's not happy. I'll let you guys watch.
A Crystal Thomas, 3 cases for sentencing, Mr. Lewis.
Yes, ma'am.
See if I can get this one right. All right, ma'am, you're a Crystal Thomas. And Ms. Thomas, you were previously in court, entered a plea of guilty to 2 state jail felony offenses of theft of property with previous convictions, and then a 3rd-degree felony of theft of property. This was an open plea. I received a copy of the pre-sentence report as well as some letters that were provided by Mr. Lewis on Ms. Thomas's behalf. Have you all had an opportunity to review all of that?
Yes, ma'am. Yes, Judge.
Any additions or corrections to the pre-sentence report?
No, Judge. No, Your Honor.
All right, Mr. Lewis, you may proceed.
Judge, as you see in the PSI report, Judge, my client does take full responsibility for her actions. Unfortunately, this is a situation where shortly after.
Well, hold on a second. Does she really?
Well, she does.
She takes full responsibility of one of them, but not the other 2.
Well, I'm talking about from where the PSI writer talks about in the recommendation, where she says that she does apologize for everything.
She does, but she also said that she doesn't remember being at Hollister on the case 1719. And she also says she also, again, really doesn't remember the 2070 case. So I think.
And I think a lot of that is what I was about to get into.
Go ahead.
Of course, his last case that was filed was in July. In August, the next month, her husband was killed. That's what she talks about, struggling mentally, since all that. This, of course, has been a tragic wake-up call for her, for his being accountable for her actions, and as well as, making sure that she does not put her freedom in jeopardy for her children, because now she has her children as well as his children at home to care for during this time period. She has been working. I know she's on leave right now from her job, but she's been working in management for Jack in the Box since this offense occurred. Well, not this offense occurred, but since I've been representing her on the new case. So that was an issue where when we got her set up with her monitor and everything for the work schedule. She does have a support system there, Judge, shown by the letters that were given to her, given on her behalf. She's more than willing to comply with whatever conditions that the court may deem fit for her on probation. She has been on probation before, and she was able to complete those things successfully. But I think even her motivation level at this point is even greater than it was then, because of the risk at hand for definitely with her children. She is primary caregiver if she's in custody. They essentially they will, of course, be in situations being separated and may not have the stability they have under her roof as they do right now. So that's a big part of the motivation for her, to make sure she doesn't make these type of mistakes again, that she is there for them. That's a driving factor for her. And even on her own initiative, for mentioning and asking for the help through Spindletop or something, to make sure that she can deal with any type of issues she's been dealing with since her husband's death, to even make it a better situation for her children. And even possibly, it's possible they may need to talk or see someone, as well. And all of that, of course, are vehicles that would be available for her if she is placed on community supervision for these officers. So that's what we're asking.
Why are you on leave? What does that mean, you're on leave?
Because she waiting on me to get over this, because I won't get my own school.
They're waiting on the outcome of this case, Judge, whether she does get, her job is aware of what's going on with her, so it's whether she gets community supervision or she's in custody, because their plan, my understanding, is to move her to her own location to be a manager.
Mr. Coleman?
Your Honor, I'll be brief. Whatever situation or collateral effects this conviction and or jail time may have on this defendant is because of her choices. The choices that she made put her in this situation, Judge. And as far as this being a wake-up call, she didn't get the wake-up call back in 2012 when she was convicted of theft. She didn't get the wake-up call back in 2015 when she was convicted of theft. Nor did she get the wake-up call in 2021 when she was convicted of theft. The situation in these cases indicates that she was acting in concert with at least two other individuals on three separate occasions to go in and commit what was essentially engaging in organized criminal activity. And she took it one step further by having a device that deactivates those security sensors that are attached to the merchandise, Judge. This wasn't a one-time lapse in judgment. She's fortunate that the state didn't file a motion to stack in these cases because we could have. This was she is a professional thief, and she was engaged in stealing with other individuals, tantamount to being engaged in organized criminal activity. We're asking for jail time, Judge. We're asking for 5 years to run concurrent on the 2 third-degree felonies and 15 months concurrent on the state jail.
I have it in my notes. There's 2 state jails and 1/3. 2 of them are state jails. The third is cause number 2070. The other 2 are state jail felonies.
Yeah.
Okay. So, Ms. Thomas, I appreciate the words that you're doing differently and you want to be better and all of those things. And I want you to, but the fact is these are, there's a way of looking at this where these are your first felonies, but the reason they're your first felonies is because you won't stop stealing and you won't take responsibility fully for what you've done. In my opinion, if you don't remember, it means there's been more times than this where you didn't get caught because there's so many. Either you remember stealing or you don't remember stealing, right? That doesn't make any sense to me. So that's not taking responsibility. And my guess is it's because there were probably so many that you can't remember specific dates. Here's the thing. You just got off of probation. You got a 1-year deferred probation on that last misdemeanor. And so the probation date was September 29th of 2021, right? So that you had a 1-year probation, October 29th of 2022, you would have been off of that probation. You actually committed the first of these 3 that last month of October of 2022. You were still on probation for stealing, and you stole again. Then you got out of jail, I'm assuming on some kind of bond, and were out of jail for a while and stole again in April. And then while you're out again, you stole with felonies pending. Knowing you have to come to court, you're still stealing. So I want you to do better, but just saying you're going to do better and me just putting you on probation is not going to do it, in my opinion. I'm not necessarily opposed to giving you an opportunity, but it is not going to be with you just walking out of here today and being on probation and just a slap on the wrist. So here's what I'm going to do. And part of the reason that I'm going to do 2 things. I want you to be able to work, right? And a felony conviction is obviously going to impact that. So I'm considering a deferred probation. That's kind of for you, but it's really more for me, especially on that 3rd-degree felony. Because if you violate, I have 10 years to give you. 10 years. You steal again, you're going to get the max. I mean, it's just somebody's got to stop you, right? So I'm going to... Okay. Cause number 23 DCCR 0116, find sufficient evidence to find you guilty. However, I'm going to defer all proceedings in that case and place you on probation for a period of 5 years. You're going to be ordered to pay a $250 fine and follow all of the rules and conditions of probation. And I'll go over those in just a second. Cause number 23, DCCR 1719, find sufficient evidence to find you guilty, but I'm going to defer all proceedings, place you on probation for a period of 5 years, order you pay a $250 fine, and follow all of the rules and conditions of probation. Finally, in cause number 23, DCCR 2070, find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for a period of 10 years. You're going to be ordered to pay a $250 fine in that case and follow all of the rules and conditions of probation. In all 3 of these cases, one of the conditions of probation is that you enter and successfully complete the cognitive track of ISF. That will hopefully give you some tools to make better decisions when you get out of that program. Because if you don't start making better decisions, 90 days is, you probably don't want to go, and 90 days is a long time, but 10 years is even longer. Do you understand? So you also will be on the mental health caseload. You have said you need some help. We're going to get you. That help is available to you for everything, for jobs, for living, you just have to ask for it and take advantage of it when it's given to you. If you don't come back in later on a motion to revoke and say, well, now I need some help. I messed up, but I need some help now. I'm trying to get you that help up front, because if you come back in here, you could be facing, in those 2 state jail felony cases, convictions and prison up to 2 years, and in the 3rd degree of conviction and prison up to 10 years. So it's very important that you follow all of those rules and take advantage of this opportunity. Mr. Coleman obviously will also be around, I'm sure, to remind me that he did not think this was probably the best thing. And I don't disagree with him fully. I really don't, but I'm going to give you this opportunity and hope that you take advantage of it. I'm going to hand you, in all 3 of the cases, trial court certifications that show these were not agreements. You do have some limited rights to appeal. You can talk to Mr. Lewis about that if you want to. And then you can go back with the bailiff. Thank you. It's a 90-day treatment to help her be better. It's just 90 days, and it's to help her so she can be successful. So it could have been a whole lot worse today. I gave her an opportunity of probation. Okay. Yes, ma'am.
So the prosecutor called her a professional thief. And I think he's right. This was a group of women who went into a store, and they all each had their own job. One of them distracted the salespeople, or 1 or 2 distracted the salespeople. One person acted as the lookout. And this girl, her job was to remove the little security tags. So she is a professional thief. And she's not going to stop just because of probation. She didn't last time. Last time she was still on probation when she got the first of these charges. So probation really doesn't mean anything to her. And I think she fully expected to take her slap on the wrist and go about her life. The only thing is the judge didn't do that. She didn't honor that agreement that she would just get a little slap on the wrist. And her mom fully expected just a slap on the wrist too. Sorry, Mom. You raised a thief. Anyway, thank you guys so much for watching. I'll keep an eye out for when she comes back, because I have a feeling she's going to. But thank you so much for watching, and I'll see you next time.